Hi, my name is Steve Thatcher and you're through to the Help with Debt YouTube video channel. Now, since I started writing this series of articles and recording the videos on Irish bankruptcy, a number of questions have arisen as a result of changes to what might or might not be the rules for governing the centre of main interest in relation to bankruptcy in Ireland. I'm getting more and more questions on how the definition of COMI, or the centre of main interest, works. Now, with increasing numbers of Irish citizens looking to explore coming across to the UK to live and work and maybe declare bankruptcy, it will be important to understand this concept. The Insolvency Services website on its bankruptcy FAQs page includes the following statement. Under the EU regulation on insolvency proceedings, if you live in a member state except Denmark, you can open insolvency proceedings, and that is make yourself bankrupt, in the country where you have your centre of main interest. Now, there is no definition of centre of main interest, but the court will usually regard the country where you carry on business or earn your living as your centre of main interest. The court will also consider the place where you normally live, i.e. your country of habitual residence, as your COMI. If you're not employed or you're self-employed, your centre of main interest will be the country you normally live in at the date of the petition. So, from the above, it is clearly the view that the starting point will be the territory where you normally live. So in order to establish your COMI, you must first move to the UK or Northern Ireland. Secondly, it is where you earn your living. For the vast majority of people, that will also be where they live. I would always advise people to live and work in the same jurisdiction. It simply avoids any question about where the true COMI lies. And I do get a number of questions from Irish people saying, well, can I live in the north and work in the south? Possibly you can, but it would be a lot simpler if you lived and worked in the north. Thirdly, it actually doesn't matter to the official receiver if you're working or not. If you're not employed, then they will take your COMI, that's your centre of main interest, as the place where you habitually live. So according to the official receiver, you can come over to the UK, live here and not work and still go bankrupt. This has been borne out by clients I have taken through the process. You must bear in mind that if you intend to relocate to the UK and establish your centre of main interest here to take advantage of the personal insolvency legislation, you should be aware that the official receiver will investigate the truth of your move. If your relocation is only temporary or false, for example, if you continue to work in the country where you formerly lived, the court can rescind the bankruptcy order. Again, this has been taken from the Insolvency Services website. Finally, there is case law helpful for those looking to establish their COMI in England and Wales or Northern Ireland. The Court of Appeal in the case of Shearson versus Veland Bodie established that the regulation permits the migration of an individual's COMI even for self-serving purposes. This conclusion respects the fundamental rights of free movements of persons and is enshrined in Article 45 of the Treaty on the Functioning of the European Union. In the UK, the official receiver versus Eschler case suggested, albeit obiter, that even a temporary move to another member state is sufficient ground for insolvency proceedings to be opened. And there is no authority stating that the debtor must reside for a minimum period of time in a state before that debtor's centre of main interest is considered to have been moved. Now, you can tell from that it's a hugely complicated area. What I would advise you to do is to take proper legal and independent advice. You can do that by calling me on 0808 160 5577 or emailing me at sthatcher@helpwithdebtuk.com. Thank you for listening.